Welcome to the Wills and Estate Transmission Podcast, brought to you by Groots, specialist lawyers in wills and estates.
Hello, my name's Dannielle. I am a solicitor at Groots Wills and Estate Lawyers, and we're here today to talk about Advance Health Directives, what they can do for you and why they're important.
Great, thank you. So thanks for that, Dannielle. And I'm just the voice on the podcast, Tony. And so what actually is an Advance Health Directive? I'm going to do it the other way, an AHD or Advance Health Directive, and why is it important?
Sure, so an Advance Health Directive, or AHD as it's commonly shortened to, is a document which allows you as the principal to give directions about your future healthcare, and it allows your wishes to be known and gives health professionals directions about the treatment that you want. You can also use an Advance Health Directive to appoint someone you trust to make decisions about your healthcare on your behalf. This person's called your attorney, and you can appoint more than one person if you choose. Up to 4 people can act for you at any one time. Your attorneys don't need any legal experience to take on this role. In Australia, there are 2 types of Advance Care Directive or Advance Health Directive, though I'm located in Queensland, where they are known as Advance Health Directives. There is firstly the Common Law Care Directive and then the Statutory Care Directive. So the Common Law Directive is created and governed by the common law. So it's a decision made by judges in the court, whereas the Statutory Care Directive is governed by specific legislation in each individual state and territory. So all states and territories, except for New South Wales, have legislation creating Advance Care Directives or Advance Health Directives. The law on Advance Care Directives is different in each Australian state and territory, unfortunately. In some cases, both statutory and common law are recognised, while in others only one may be so. In Queensland, only statutory Advance Health Directives are legally binding. In New South Wales, only common law care directives are legally binding, as they don't have any statutory legislation around advance care directives. They do have guardians and things similar, but again, similar is not the same. So in Victoria, a person can make a common law advance care directive that refuses treatment, or a statutory advance care directive. And then in the ACT, the Northern Territory and South Australia, as well as Tasmania and Western Australia, a person can make a common law and or a statutory care directive as well. So there is scope across these jurisdictions for one state or territory to recognise another's statutory or common law care directive. However, the law is complex in all of those areas and differs between each state and territory, obviously, depending which one is allowed. There is, for that reason, quite an emphasis on getting specific legal advice in the state or territory that you want them to apply to.
Yeah, and this is the interesting thing, isn't it? That we've covered this before, the shall we call it, legal state of origin.
Yes.
And yeah, New South Wales and Queensland hate each other, and the NRL state of origin and all sorts of things and what have you. And people think they can do wills and advanced health directives and everything else from something from a newsagent or the back of an envelope or back of a stamp, whatever it might be. But it's so much more complex than that.
Absolutely. We see so many issues arising from those just blanket forms and things like that that just don't apply to each jurisdiction, unfortunately.
Yeah, it gets very messy. Okay,
Yeah.
So what is the difference between an enduring power of attorney and an advanced health directive?
Yeah, so under an enduring power of attorney, as we've covered in previous instalments by my colleagues of the podcast, you, again as the principal, can appoint attorneys for financial matters. You can also appoint attorneys for medical and personal matters. You can't do that, appoint financial attorneys under an Advance Health Directive. So under the Advance Health Directive, you can only appoint attorneys for personal and health matters. The use of both documents can be helpful, where you have, say, different people that you'd trust with your personal matters as opposed to your financial matters. It's sometimes quite beneficial to have them separated, because if you're having someone appointed for financial matters and you intend for them to begin acting immediately, it can be helpful to separate that from your personal matters, which can obviously only begin, or someone can only begin acting for you on personal matters once you lose capacity. So it can be, as I say, helpful for them to work alongside each other as opposed to be under the one enduring power of attorney document.
Yeah, and again, we've got another wonderful little quirk of everything. Another little thing that can come up is, how does an advance health directive differ from a living will or a do not resuscitate, DNR? We've seen all that in the ER shows, and no, it's got a DNR and what have you, but how does that all apply together?
Yeah, so in Queensland specifically, a DNR order is made under the Advance Health Directive, technically speaking. So in other states and territories of the country, the relevant care directive or guardianship or anything like that, appointment of medical decision maker, etc., is the document under which you'd make such a request. So in all instances, this document is often requested by, but should always be given to, your general practitioner, the regular hospital you visit, any other healthcare professionals that you regularly see, so that your wishes are recorded, specifically around those sort of do not resuscitate things that are quite serious and need to be noted by those people. A living will is a colloquial term, generally, that is used for those various documents. So largely this is simply a document allowing you to describe how you wish for your medical treatment to be carried out in the event of your incapacity. So you're still alive, but unable to provide direction, hence a living will.
Excellent, okay. So what types of decisions can I specify in an advance health directive? We've covered some. So what else is there that we can possibly cover?
Yes, so there are various sections of the document which allow you to outline your decisions about specific matters, but there is also a section which allows you to specify what your views, wishes and preferences are. So in that section, you can express anything that's important to you regarding the quality of life you expect on your loss of capacity, if you do lose capacity. For example, you might wish to request that a religious figure is present in your last moments, that you always want a room with a view, you wish to get at least 2 hours outside every day, you'd like certain enemies to stay away from you. The list goes on endlessly. Really, this is a section for you to let your attorneys know what and who is important to you. Again, when you're unable to provide that information down the line. As I stated earlier, there's also a document under which you can express your consent to or refusal of life-sustaining treatments. So you can be specific here and let your attorneys know that you don't want CPR, but you do want, artificial nutrition or hydration, things like that. Similarly, you can provide a blanket refusal or approval of this. So you can simply say, I don't know yet as well, which means your attorneys will decide. In that case, they will obviously consult with your healthcare team and make sure that it's the best decision for you at the time. But another common thought for people, particularly those with specific religious or spiritual beliefs, is about blood transfusions. So in the Advance Health Directive, you are able to consent to or refuse transfusions generally, or specific types of transfusions, anything like that. So that's another bit where the living will comes into play. So it allows you to be very specific in what you want when you're unable to say at the time.
All right, so talking about those sort of things to do with blood and transfusion and everything else, can I specify organisation preferences?
Yeah, absolutely. It's important to note that much the same as an enduring power of attorney, which again we've touched on previously, is that on your death, the authority of the Advance Health Directive document ceases. So as such, you're able to express the wish that your organs are donated or not, to give your attorneys and your medical team a heads up and the foresight required for organ harvesting, essentially. But once you've passed away, this document's no longer relevant, and your executor appointed under your will then steps in. So on your death, your executors are then in charge of disposal of your body and therefore organs.
So, who can make healthcare decisions for me if I don't have an advanced healthcare directive in place?
So in Queensland, the government's very clear on who can make decisions for you if you have no health attorney appointed. So statutory health attorney make health decisions on your behalf if you've not made an advance health directive. But similarly, if you've not appointed an attorney under an enduring power of attorney document for health matters, or had a guardian appointed for healthcare matters by QCAT, which is the Queensland Civil and Administrative Tribunal. So your statutory health attorney is the first person who is 18 or older, who's readily available and culturally appropriate to exercise the power for a health matter. And there's an order of priority for those people. So first and foremost is your spouse, if you have one. That does include, for this particular matter, a de facto or a civil partner. And then the next person is your carer, who's not a paid carer. So that doesn't mean like an NDIS service provider or anything. Someone who cares for you but's not paid to do so. And it's not a health provider or service or anything like that. The next one is a close friend or a relation who's in a close relationship with you. So that's obviously a bit subjective, but again, they can't be a paid carer or healthcare provider or anything like that. If no one's readily available or culturally appropriate, then the public guardian acts as a last resort. Last resort is quite emphasised there because they obviously want to give as much possibility as possible as they can for someone who knows you to step into that role. And then a statutory health attorney, it is important to note though, can't consent to forensic examinations or special health matters like tissue donation, sterilisation, pregnancy termination. So they can't act on any of those things for you. Only QCAT can make those decisions ultimately.
All right, QCAT or the equivalent in each state?
Yes, yeah, or the equivalent.
Yeah. So can I change or update my Advance Health Directive if my preferences change over time? And that includes in relation to pain management or palliative care?
Yeah, definitely. So while you have capacity, you can change, revoke, update any enduring power of attorney or Advance Health Directive as many times as is required to make sure that your wishes remain current and that they're adequately reflected. In amongst the sections of the document, there are various places for you to record preferences about non-life-saving treatments, as we've discussed, and pain management and palliative care and things. You can express them as wishes in that Views, Wishes and Preferences section, or you can make specific directions, particularly where you have, say, a health condition that is particularly painful and you're currently on pain management medication. Things like that can be specifically recorded as opposed to expressed as a general wish for the future.
Great. Well, look, thank you very much for that. So this comes to the end of this particular part of this topic. We've got plenty more to discuss, including what if my family members disagree with my decisions, and is actually an Advance Health Directive actually even legally binding? So join us for the next podcast where we cover that and other items.
Thanks for listening.
Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website www.degroots.com.au and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.